I'd like to talk with you a little bit about sex crimes as defined in Kansas. There are a wide variety of different crimes and allegations that have different names, different monikers, and different penalties when it comes to allegations of sexual impropriety. The first crime that many people hear of and has an almost immediate reaction is the crime of rape. Rape is the crime of non-consensual sexual intercourse. This means that there's various types of intercourse. Intercourse includes any penile penetration, any digital penetration, meaning using a finger or a hand, or any penetration with any object of the female genitalia. That means that women can be the victim of a rape, but men cannot be a victim of a rape, and that's a common misconception. The crime of rape can happen in a variety of different ways. Many people, just because of Hollywood or uh, things that they've heard or seen on TV, assume that rape means it's with a stranger, or it means somebody's wearing a mask, or climbs in through a window and forces themselves on someone. That is one means by which rape can be uh, uh, can occur, but there are other forms of rape. So the first would be by force or fear. Any intercourse that is done as a result of force or fear meets the definition in Kansas of the crime of rape. There's also rape when someone is under the influence of alcohol or drugs to the extent that they can't give legal consent. So if you're so impaired by alcohol or drugs that you don't know what you're doing, and that is something that either law enforcement or a prosecutor believes that they can prove to a judge or jury, they can charge someone with the crime of rape. There's rape by means when a victim is unconscious or physically powerless. So whether that means because they were so under the influence of alcohol or drugs that they lost consciousness, they were under the influence of prescription medication or some other means by which they lost consciousness, or physically powerless, meaning they're incapacitated in a hospital or a nursing home facility and they can't protect themselves or defend against any intercourse or penetration. That's the first crime. Second crime that many people are familiar with or have heard of is aggravated criminal sodomy. Aggravated criminal sodomy means any penetration or contact of a person's anus or mouth that is done by generally the same means of rape that I just discussed. So if there's any penetration, oral or anal penetration by force or fear, that would meet the definition of aggravated criminal sodomy. If someone is under the influence of alcohol or drugs that they can't consent, if someone is unconscious or physically powerless and can't consent. Now, another means by which either rape or aggravated criminal sodomy could be carried out would be by deceit. And the best example of that would be if someone is engaged in a sex act, intercourse, or sodomy with someone, the lights are out, and that person believes that they're having sex with someone that they consented to engaging in that act with, and then another individual comes into the dark room and takes over and then engages in that act, and the victim is not aware of or unknowingly continues to engage in that act without having given consent to another person. So those are the various means by which those two crimes can be committed. Another crime that often gets charged in Kansas is either indecent liberties or aggravated indecent liberties. And the thing about sex crimes in Kansas are that they're generally defined by a couple of different factors. Number one is, what is the act that actually took place? Is it intercourse? Is it lewd fondling or touching? Is it sodomy? Is it exposure to a particular type of material that someone should not have been exposed to? Is it the recording of a particular type of act? So there's a couple different factors that are relevant. The age, so the act that actually takes place is one factor. The age of the complaining witness or victim is a factor. The age of the perpetrator or the accused, that is a factor. And then what other things exist that might cause there to be a different type of crime that becomes applicable. Those are all factors that we can discuss. So indecent liberties generally refers to any lewd or lascivious, meaning sexually motivated act by someone between the ages of 14 and 16. So someone over the age of 14, but less than the age of consent. Any lewd fondling or touching at all, as long as it is sexually motivated, would qualify or meet the definition of indecent liberties. Aggravated indecent liberties is a little bit more serious crime. Aggravated indecent liberties means there's intercourse that happens with someone who's under the age of 14, a statutory offense. So if someone is under the age of 14, whether they believe that they're consenting or not, that would qualify as the crime of rape. Likewise with aggravated criminal sodomy. But aggravated indecent liberties can be intercourse with someone between the ages of 14 or 16, or any lewd fondling or touching of someone who's under the age of 14. Again, aggravated indecent liberties is often has the same acts as indecent liberties. The difference is the age, and then again, intercourse would be more serious and therefore qualifies aggravated indecent liberties. Aggravated indecent solicitation or criminal solicitation. This would be soliciting or enticing someone to engage in some form of sex act, whether that's intercourse, whether that's sodomy, whether that's lewd fondling or touching. So if you solicit or entice someone who's under the age of consent to engage in a sex act or participate in some form of sexual activity, the difference between indecent solicitation and aggravated indecent solicitation, again, is the age. So under the age of 16, but over the age of 14 would be indecent solicitation. Under the age of 14 is aggravated indecent solicitation and has higher consequences and more severe penalties. Lewd and lascivious behavior. Many people throw around the term lewd and lascivious behavior. What does not qualify as lewd and lascivious behavior would be urinating in public, for example, and someone happening to observe someone's genitals being exposed for something other than sexual purposes. Excuse me, lewd and lascivious behavior that does meet the definition would be engaging in a sex act. So whether that be intercourse or sodomy or any lewd fondling or touching where genitals are exposed, that is in fact lewd and lascivious behavior. Lewd and lascivious behavior, severity level of that offense is dependent completely upon the age of the individual who observes or is present at the time that that act occurred. So if someone is under the age of 16, lewd and lascivious behavior is a felony. If someone is over the age of 16 and observes a particular act, then it's also lewd and lascivious behavior, but it is a lower level offense. Adultery, this is a crime that's rarely charged, but it is still statute that lays out a crime in Kansas. Adultery would be engaging in any sexual activity with someone that you are not legally married to. Again, this is not something that generally is charged absent some extenuating circumstances. In other words, someone that's unfaithful in their marriage and has sexual activity with someone outside of their marriage technically has engaged in the crime of has engaged in the crime of adultery. But again, that's not a crime that we see very often. Promoting prostitution, that's another crime that can be charged here in Kansas. Promoting prostitution often involves one of a couple things, either managing or providing a house of prostitution, meaning you're providing a location where prostitution activities, meaning the sale of sexual services, occurs. So whether that means you're running or working in a massage parlor and sexual activity is exchanged for financial goods, or allowing those types of activities to happen within your home. So knowingly exchanging sexual favors for some monetary gain or some other gain, that is prostitution. Actually engaging in the crime of prostitution is in fact a crime as well, but promoting prostitution, meaning you're financially gaining from someone else engaging in prostitution, often carries with it higher penalties. There's also the crime of sexual battery or aggravated sexual battery. The best analogy I could draw would be if you're on a sports team and after a good play, you slap somebody on the butt, or you're playing a prank and you poke somebody on their breast, or you tickle somebody or something. It may not be wanted, but just because you have that type of contact does not actually make it a crime. The thing that causes it to be a chargeable offense would be if the nature of the touching is done specifically with sexual intent. So slapping somebody on the butt during the middle of a sports game, for example, that's not a crime because it's going to be difficult for a prosecutor to ever prove, or a judge or jury to ever believe that that type of contact was done for sexual motivated purposes. However, if you're in a bar or in a restaurant or at a party and you touch somebody in a sexual way and they do not consent to that touching, that does qualify as a crime, either of sexual battery or aggravated sexual battery. Aggravated sexual battery simply means that that type of contact was done by force, or by fear, meaning you threaten or you corner somebody and you don't allow them to move and you touch them against their will, and they were overcome by force or fear when that contact actually occurred. So aggravated sexual battery carries with it higher penalties and more severe consequences than your standard sexual battery charge. There's a subsect of sex crimes laws in Kansas called unlawful sexual relations. Unlawful sexual relations pertains to sexual contact that occurs between two parties where the nature of their interaction or the nature of the relationship is one where there is a significant difference in the balance of power, meaning somehow the sexual contact that occurred because of the imbalance in power that's just strictly prohibited by law. So any sexual contact that happens between an inmate in a corrections facility or a jail, where they may have consensually agreed to it, they can't by law consent to a sex act with someone who's a jailer or a corrections officer or a law enforcement officer. That would pertain to a crime known as unlawful sexual relations. Another relationship that inherently is imbalanced and qualifies as unlawful sexual relations would be any sexual contact that occurs between a teacher and a student. Our legislature has determined that there are just some situations where there is such an imbalance in power or such a heightened risk of the person engaging in the sex act with somebody who holds a position of authority over them runs a risk where they don't feel comfortable consenting or saying no because of the consequences of refusing to engage in that act. There's also a form of or a subsect of sex crimes laws in Kansas known as unlawful voluntary sexual relations. And this is commonly referred to as Romeo and Juliet laws. And what this means is there are some crimes that were discussed earlier by Ashley that are simply statutory offenses, meaning because an individual in Kansas in particular is under the age of 16, they cannot lawfully give consent to engage in that act. However, the legislature has acknowledged and believes that there are some circumstances where those crimes tend to happen on a more frequent basis. And where we see that very often is in children or in youth who are within the same high school cycle, so within a 4-year window of range between one another. The idea is that it's not unusual for two people to become involved in some sort of romantic relationship or sexual relationship when they attend school at the same place. So if you're a freshman or a sophomore in high school, for example, so you're over the age of 14 but less than 16, and you engage in some act, whether it be intercourse or sodomy or any lewd fondling or touching with an individual who's over the age of 16, but they're less than 4 years older than you, then those crimes carry with it significantly lesser penalties than those crimes when the perpetrator or the alleged suspect is over the age of 19. So any intercourse, again, sodomy, lewd fondling, or touching, if there is less than a 4-year age gap between the two parties, the suspect and the complaining witness, and that crime would otherwise be consensual, but for the fact that there are statutory prohibitions and limitations on when somebody can give consent, those crimes can still be charged and often are charged, and they are felonies. But the difference between this area of the law and other sex crimes is that a unlawful voluntary sex crime, meaning a Romeo and Juliet crime, as we refer to it, does not carry with it the mandatory requirement of sex offender registration if you are convicted. It also is what we call an expungible offense, which means that down the road, you can petition through your attorney or on your own for the court to seal your record so that you no longer have to admit that you were ever arrested, charged, or convicted of that crime. In other words, it's easier to expunge a crime that falls under the Romeo and Juliet laws than any other sex crime where there's either a larger disparity in age or there was force or fear involved or a lack of consent. So the legislature and prosecutors and courts all recognize that oftentimes there are unlawful sex acts that occur that happen more by the nature of the contact or the social circle that individuals will frequent. There's also the crime of aggravated incest. So there are some sex crimes, and these would be also statutory, meaning It doesn't matter whether these acts are otherwise consensual. Any crime or any sex acts that occurred between certain people in a particular familial relationship are strictly prohibited by law. So you cannot consensually engage in any sex act with another individual who is either your parent, a step parent, an aunt, an uncle, a sibling, a step sibling, grandparents. So there's a wide array of just familial relationships that strictly prohibit any sexual activity at all. And again, the legislature has contemplated that oftentimes sex crimes occur with people that we're closest to or that we have the most contact with, and oftentimes that we trust. And therefore, there are laws that are just strictly prohibited, again, whether they're otherwise consensual or not. There are many crimes that I would refer to as technology-based sex crimes. Technology-based sex crimes are those crimes that don't necessarily refer to physical contact between parties, but more crimes that happen as a direct result of some technological medium. So whether that means a camera, a computer, a cell phone. So some form of technology has been utilized by a suspect or a perpetrator to carry out a sex crime. Sexual exploitation of a child, that is the crime that we see the most in Kansas. And sexual exploitation, the general term that is thrown around or society refers to as possession of child pornography. So any sexually explicit images of someone under the age of 18 are strictly prohibited by law. So it is unlawful for you, even two people over the age of consent, so two people who are over the age of 16, to either photograph or record through video transmission, or to otherwise record or possess any sexually explicit images of someone under the age of 18. And what's very fact specific and really the key in whether or not somebody can be convicted of a crime like this is that the image actually has to be used for a sexually explicit purpose. It has to primarily or predominantly be a sexually explicit image that has no other either artistic value or no innocent explanation. So if you're recording or taking photographs of your children in a bathtub because it's cute and you want to record that type of memory, that's not necessarily possession of child pornography, because that image or that recording is not being recorded for sexual purposes, and it's not an image or a recording that focuses narrowly on the sex organs, and certainly not a sex act. But sexual exploitation of a child or possession of child pornography is a crime that is pretty routinely charged in Kansas. And those crimes come to law enforcement's attention in a variety of different ways. So if someone sees on your computer or on your phone an image of a child or someone under the age of 18 in a sexually compromised position, that can be sexual exploitation of a child or child pornography. The transmission of child pornography, so emailing it or texting it or sharing files or images through computers through some sort of a file sharing program, like Kazaa or LimeWire or any website where there are individuals who are exchanging these types of images or videos as if they were trading cards, for example. Those are all crimes that would fall under what I would call a technological or a technology-based sex crime. Another technology-based sex crime would be invasion of privacy. This crime has actually come about in the recent past as technology has advanced. There are many more recording devices that are available to the general public. Ring cameras, recording devices, cameras that are hidden in someone's bedroom, someone utilizing their cell phone to record a sex act, whether that's intercourse or someone showering. If there is a recording of someone engaged in a sexually compromising position or that is intended to record somebody in a state of undress, and it is done surreptitiously, meaning without the consent of the party being recorded, that would be an invasion of privacy or a breach of privacy. And when that crime occurs, if it is in fact done for sexual purposes, that crime or conviction for that crime often carried with it the consequence of having to register as a sex offender, just like any other sex crime that happens for actual physical contact. So many of these crimes do carry with it the risk of sex offender registration, and we can talk about that a little bit further down the road. But sex offender registration is obviously a big concern and a big risk for people who are facing allegations or facing the risk of a conviction for a sex crime. The other crime that we see often, and again, this is a relatively new crime over the past 10 years or so, is electronic solicitation of a child. If you utilize a computer or a phone for the purposes of contacting and soliciting or enticing a child to engage in a sex act, the legislature has carved out an area of the law called electronic solicitation. I think what most people are often familiar with is a show that was on TV years ago called Dateline, To Catch a Predator. This is a situation where somebody will pose as a individual, often holding themselves out to be a minor or someone who's age appropriate, where they're wanting to discuss sex acts or sexual contact with somebody who's underage. Many times they will entice or solicit somebody to share photographs of themselves or to share video recordings of themselves, or worse, to actually meet and to engage in a sex act. So if you use a smartphone or a telephone or email or a program where you can actually chat through live chats, this would qualify as electronic solicitation of a child. And the severity level of that offense rests entirely on the age of the individual that you're seeking to engage in a sex act with. So it's more serious to engage in a chat or communication with somebody, enticing them to engage in a sex act, if you believe that individual to be between the ages of 14 and 16, as opposed to enticing or asking or discussing sexual acts or behaviors or interactions with somebody that you believe to be under the age of 14. Many of these crimes come about because law enforcement officers will hold themselves out as a minor or a child or an adult and pay special attention to or prey upon juveniles, knowing that they're susceptible because of their access to electronic mediums that maybe their parents aren't aware of. We saw this a lot with what we would call latchkey kids. So kids who are home, not being monitored on their computer or on their phones, and there was someone in the public that was reaching out to them, asking them to meet and engage in a sex act, fully knowing that that person might be more susceptible to engaging in that type of crime because their parents weren't aware of the contact. So the legislature created an area of the law where it is illegal to engage in any type of sexual communication where you're enticing or soliciting a sex act from someone that you believe to be underage. Each of those crimes has different penalties and different consequences, whether it's a period of probation or a period of prison or a more significant period of incarceration, as well as sex offender registration.